Good afternoon and welcome to this meeting of Rother's Licensing and General Purposes Committee General Licensing Panel. This meeting is being filmed and recorded by Rother District Council and live streamed and will be available afterwards on the website. We're also being filmed and recorded by a member of the public. At this point I hand over to Louise Hollingsworth, our committee clerk, for the election of a chair.
Thank you, Councillor. First item on the agenda is the election of chair. Could I have your nominations, please?
Nominate Councillor Mear.
I second. Okay, thank you very much, Councillor Mear.
Thank you, councillors. And we have here today Councillor Stanger and Councillor Cooper, and I am Councillor Mear. The second item on the agenda is to authorise the chair to sign the minutes of the meeting of the General Licensing Panel held on the 1st of July 2024 as a correct record of the proceedings. Councillors, are we content?
Agreed.
Agreed.
I will sign.
Your name's gone.
And today's the 14th. Thank you. Item 3, apologies for absence. Clearly there are none.
No, there are none, Chair.
Disclosure of interests and dispensations. To receive any disclosures by members of disclosable pecuniary interests, other registrable interests, non-registrable interests in matters on the agenda, and the nature of any interest and details of any dispensations obtained. Members are reminded of the need to repeat their declaration immediately prior to the commencement of the item in question. Are there any declarations? None. Item 5, application for the grant of a variation of a premises licence number 29898 for 54 to 55 High Street, Battle, East Sussex, TN35 0EN. And this is, of course, the Chapel Bar and Restaurant. I've introduced councillors already. Go round and just say briefly who we have here. We have Nick Semper from the licensing guys.
I'm the agent of the applicant, sir.
And we have Anna Stewart, the applicant herself.
Yeah, hi, Anna Stewart.
Thank you. And for Mark Randolph for environmental health, Daniel Bancroft for licensing, and Chris Godfrey licensing too. We have also Mr. Cowan, Rob Cowan, who is our legal advisor.
Yes, Chair, I'm the legal advisor today. Can I just clarify? Mark Randolph is from the licensing department, Daniel Bantoff, environmental health. Is that correct? Yes. Thank you.
My mistake. And we also have...
Sorry. Good afternoon, Linda Birch, on behalf of the applicant.
I'm Ashley Eden, in behalf of the applicant.
So, Mr. Godfrey, would you introduce your report to us, please?
Thank you, Chair. The report follows the standard format, and with your permission, I will not read it word for word, but will highlight the salient points for the benefit of the committee. This matter concerns an application to vary the existing premises licence for the Chapel Restaurant and Bar located at 54 and 55 High Street, Battle, East Sussex. The application has been submitted by the Battle Chapel Limited. The premises is situated on the commercial high street opposite the Bull Inn and is flanked by other commercial premises with residential accommodation above. A location plan, proposed amended licence plan and site photographs are included at appendices A, B and C of the report. The application seeks to vary the current licence as follows. Extend the hours for the sale and supply of alcohol into later evening hours on Fridays and Saturdays to 12:30 a.m. With minor extensions to Monday to Thursday and include off sales. To extend the opening hours to match the proposed alcohol sales, including earlier opening from 9 a.m. on weekends. Extend the hours for live music on Thursdays through Saturdays to allow performances until 12:30 a.m. on Fridays and Saturdays. Extend alcohol sales and opening hours to 1 a.m. on New Year's Eve. Add a new licensable activity, which is late night refreshment on Fridays and Saturdays from 11 p.m. to 12:30 a.m. To include the front alcohol area within the licensed premises to permit consumption of alcohol in that space and reflect all the proposed changes within an updated premises plan. The applicant has stated the intention behind these changes is to ensure fairness and parity with nearby licensed premises, particularly the Bull Inn opposite, to support better late night customer management and to aid business sustainability. They highlight that when their venue closes at 11 p.m, customers often move to the Bull Inn and they believe staying open later would assist in managing behaviour and reduce nuisance. The application received 6 representations in objection and 4 in support. Concerns raised by the objectors include the potential for increased noise, public nuisance and disorder, especially during the late night hours. The application has also received a formal objection from the Council's pollution team relating to noise concerns. Sussex Police did not raise an objection. The premises are subject to a noise abatement notice issued in December 2024. Since the notice was served, there has been no evidence of any breach. I understand that this notice remains indefinitely unless revoked by the local authority. There are historic complaints in relation to the premises, which they've been detailed in the report. In terms of planning, while the planning department did not submit a formal representation, they did provide comments for reference, noting that the current use of the premises as a bar had not been regularised by planning permission. I would point out that since the writing of the report for this hearing, the applicant has in fact now submitted a planning application and that it was submitted within the time frame required. Members are reminded that the licensing and planning are separate regimes and the absence of planning consent does not prevent the licensing authority from determining this application. Planning comments are not relevant representations under the Licensing Act 2003 and do not carry weight in licensing decisions. The applicant's operating schedule is provided in Appendix D. It outlines measures intended to promote the 4 licensing objectives, including noise control measures, limiting the use of outdoor area after 11 p.m, and engagement with neighbours. However, no specific conditions have been proposed regarding capacity or seating in the alcove area. As you can see that in Appendix C in a photograph. Members may wish to consider further how the number of patrons will be effectively controlled and managed within this small licensed outside area and what measures will be implemented to prevent any overflow of patrons onto the public highway, thereby avoiding any obstruction. Since the report was published, the applicant has provided further information to be considered in respect of their application. They have put forward the implementation of both a dispersal policy for the terminal hour and a noise management policy. Furthermore, an acoustics report on crime and antisocial behaviour data, which was for the immediate area of the premises, were also submitted for consideration. I believe all the aforementioned documentation has been circulated to all members and parties. To sum up really, the panel is asked to consider the application and representations received. The options available are to grant a licence variation as applied for, with or without modifications, to exclude any of the proposed licensable activities, or to reject the application in whole or in part. In reaching a decision, members are reminded to consider the licensing objectives and evidence before them. A reason must be given for any decision made. Thank you, Chair. That concludes my summary.
Thank you very much. Councillors, Do you have any questions for Mr. Godfrey at this stage? There was just one point of clarification that I wanted, and I'm sure the applicant will tell us about it, but I'll ask you first. The courtyard in which it is alleged that some poor behaviour has occurred, is that part of the premises? Is that under the control of the applicant?
No, that's not part of the premises as far as I'm aware, no.
Thank you. And the acoustic report that's been submitted, I think that was on the basis of the existing hours rather than the extended hours sought.
I'm not entirely sure with regard to that.
Mr. Semper will put us right in due course on that. Yes, at the moment, the Bull Inn opposite has different hours from the Chapel Bar, so that the licensing hours are staggered. Is that a good or a bad thing in the views of Rother and Rother's policies?
That's a good point. Be one that you could ask the applicant. It's not in our policy regarding staggered hours like you'd have perhaps in a city centre to aid dispersal. There's no plan that the licensing team have put together to take effect in Battle. I'm not sure we're at that situation yet. It's just a historic reason why the board have got those hours. The Chapel Bar applied to certain hours and were granted, and now the applicant's asking for hours to be equitable with other licensed premises. There's no plan in place to have staggered dispersal throughout Battle. I think if that was an issue, the Sussex Police would have raised it as part of this application.
Later. But Councillor Stanger.
Yeah, just a question on the proposed variation of the licensing hours on Friday, Saturday. So they're saying the closing hours is going to be 12:30 and the sale of alcohol is 12:30. Is that unusual in the case of, should there no be a period in between the sale of alcohol stopping and the premises closing? Or?
It depends. I think sometimes the police want some sort of drinking up time, so some do, some don't.
Councillor, it's quite common for the Sussex Police to ask for drinking up time, so they would reduce alcohol hours, perhaps 20 minutes, half an hour before opening hours terminated. And that's something certainly the panel could consider in this application.
Thank you.
And I just have a question about, there's an application to allow off sales. Is there any particular justification for not having off sales when there's an on sales licence? Which particular consideration would that affect?
Off sales is something Sussex Police would have raised if it's an issue. It's quite common for licensed premises, including restaurants, to have off sales. One, to cover somebody might just go in to buy a bottle of wine to take home, or they may not have finished a bottle of wine while they're having something to eat, and they can take that home as well.
Thank you. Unless councillors have any other questions? Thank you very much, both. Thank you. We then come to the responsible authorities. And does environmental health come under this heading? Yes. Yes, please, Mr. Boncroft.
So I'm representing the responsible authorities as I work in pollution and environmental health. My sort of history with this premises was that I was involved in investigating the noise complaints that I took at the end of last year and subsequently served the abatement notice. After the abatement notice was served, there were some still minor complaints going on up until the Christmas period, as this was served on the 5th of December. However, coming up back after the Christmas break, there was significant work done by the Chapel Bar, I think, to alleviate the issues, and that's when the acoustic report has been done, and they've installed some new equipment, including a noise limiter, etc. And actually, they're working well with the neighbours now, which has seen a significant improvement in the area. The reason for the objection is looking at if we're extending the hours. At the moment, going until 11 o'clock is deemed sufficient because you're going up to nighttime hours. If you've got adjoining residential properties to this premises, once you're starting to look at having live music going on until 12:30 at night, that could cause significant disruption to them, and against the sort of licensing objectives, that's looking at the sort of public nuisance element. But I think there's obviously been a lot of work done as well. We've had subsequent, like an improved dispersal policy and noise management plan has been submitted, and we've actually had some discussion just before the hearing about setting the noise limiter that they've got in there as well.
Yeah, thank you. Regarding the change of licensable area, so they want to include the front courtyard, what is your specific concerns regarding that, especially up till they say the tables will be removed at 11 o'clock, but it won't stop people drinking there necessarily, will it?
No, there is concern for the amount of people actually that would be out the front of the premises. If they're removing the tables, again, you've got to look at what these people are doing with their drinks, whether they're holding them, if they're starting to put them on the floor, if they could end up with sort of broken glass and noise from that side of things. And a number of people that are congregating in this area, it's, for those that are familiar with it, it's quite, you sort of go down the steps and you're straight onto the pavement there. It'd be very easy to be sort of blocking the pavement there. It's quite late at night. Even when I visited late in November, I was there at about 10 o'clock at night, and there were quite a significant number of people outside the front of the premises at the time. But I think it would be ideal to sort of limit that on the people drinking outside, say to 10 o'clock would be something that I think would be reasonable. But if they're removing the tables at 11, if that's already in their policy, that may be deemed sufficient.
Thank you.
And Councillor Cooper.
Yeah, it's just, you kind of half answered, but if we were minded to approve this, are there further conditions that we could apply that might mitigate some of the concerns that have been raised?
Yes, as I say, to be looking at restricting the hours of when people can drink outside. I think it's, even on the current licence, it says customers will not be permitted to take alcohol outside the premises to consume. So I think that's already on their current licence anyway, that they shouldn't be on there. If they're expanding their licensable area, presume that it would be with a view to looking at removing that from their current licence so that people can drink outside if they're expanding that area. But it should be perhaps restricted to, say, 10 o'clock. And then that looks for like again, it's this easing down time as you're going towards the nighttime hours to prevent the public nuisance element.
I have a question. Regarding the noise abatement notice, you say since some acoustic work was done in January, there appear to have been no complaints. Of course, I suppose it's just possible that the complainants have been waiting for today to make their point. I don't know. But did you conduct any sound investigations within the neighbouring flats?
Yes, as part of my investigation, I had a noise recorder installed in one of the nearby residential flats, and it's actually adjacent to the premises. And that was my initial investigation, and from that I thought this is quite a serious issue. And then I followed that up with a visit in person on, I think it was a Saturday night, and went and witnessed. And again, there was quite a serious sort of noise disturbance in their property, which is what led to the abatement notice being served. As we sort of mentioned, you've addressed that, and I think it was predominantly the bass noise, which is what generally carries through sort of structure-borne noise, that was causing the issue.
And since have you visited since the new equipment was put in? Have you been since? And if you have, was there still any noise?
No, I haven't had reason to visit because we haven't had any further complaints. And as I understand, they've been in fairly regular sort of contact as and when they've needed to with the premises holder.
Councillor Stanger.
With regard to the live music till 12:30 on Friday, Saturday, do you think the noise limiter will still cover that, still maintain a reasonable level at that time of night?
It's difficult to say really, without sort of
I've used one of the machines before. I know how they work, but
yes, in theory, yes, it should work, but you never really know, to be honest. Especially with these sort of type of buildings that you've got in Battle, a lot of these are sort of listed buildings. There might be faults with the way that they're designed. You don't know how the sound's going to carry, but I think I think in our discussions just before this, they mentioned that when the acoustic report was being done, that there was some work done with the neighbour then to sort of set a limit, and that might be why we haven't had any complaints since. But we said that we'll look at setting a noise limit should this be granted anyway.
Thank you.
Mr. Randolph.
Sorry, Chair. Just a question the panel may consider asking Mr. Bontoff about the practicalities of monitoring live music, because like recorded music, you can turn the volume down. A live band, amplified or unamplified, difficult to control, especially unamplified live music. Maybe we should ask him about the practicalities of how you've reduced the volume of a live band that's not amplified.
Yes, well, I suppose I'd just make an observation that I presume that acoustic music in its nature tends to be quieter than amplified music, but of course I may be wrong about that. Perhaps you could answer the question.
This is, again, it's a bit of a difficult thing. It depends what band or what is being played in there. You might have a sort of DJ with completely electronic kit. As I understand it, I have a feeling you have the system in place that they can plug into, which is what the limiter is actually attached to, so it should cut it out. If you have bands in there with, say, drums, etc., again, these might still be audible. You can't sort of control the limit of them unless they have a sort of an electric drum kit or something that can be reduced by it. But that'd be down to the sort of management decision on what they're hiring there. But if this is going on until 12:30, as we said, practicalities of actually monitoring this could be an issue and could lead to sort of further disturbances. But I think it'll be down to how this is managed.
And I think this might be my last question. I'm not sure. I think you indicated that noise management plans are not always effective. What's the reason for saying that?
Again, this is something that is more born out of experience. I don't want to shoot down noise management plans. They're a useful tool to have, but ultimately, if you're working in a premises on a busy, say, Friday night, staff, if you've got all these expectations of staff in there to monitor people outside the front of the premises to stop people leaving and sort of being outside and making noise, you can put all the signage up that you like, but these might not always be effective measures to members of the public that don't want to take notice of them. The management plan that has subsequently been submitted is a lot more sort of robust and actually looks a lot more effective than what was initially submitted with the initial application for the variation.
Yes, that's helpful. Thank you.
Only just the one quick point. I'm not sure it's relevant to you, but the late night refreshment edition. So that would be that late night refreshment covers eating, takeaway type food of any type, hot food, or just that covers all that, does it?
Yeah, hot food and drink, including tea and coffee.
Oh, tea and coffee as well, yeah.
Are there other questions from councillors?
No.
Thank you. Mr. Semper, I suppose I should have given you an opportunity to chip in there. Do you want to ask the officers any questions now?
No, I think they've been very fair. I would point out that unamplified I would point out that unamplified music is not a licensable activity and doesn't lie within the remit of this committee, but that's just a technical point. But they've been very fair. Thank you.
Well, thank you all very much.
Mark Randolph.
So unamplified live music after 11 o'clock is licensable activity. And I understand the application wants to go to 12:30.
Thank you both. We then come on to the applicant or Mr. Semper to present the case for the variations.
Okay. So here we go. I am Nick Semper for the licensing guys, and we're representing the applicant here today, the Battle Chapel Limited, here in the persons of Miss Anna Stewart. Now, this is a variation and not a review of a premises licence. The nature of the premises, the clientele, the activities conducted will remain unchanged. Essentially, what is sought is the ability to make off sales and an extension of hours to midnight for licensable activities to match other premises nearby, thus enabling them to compete on a level playing field. Indeed, the Bull Inn across the road can stay open until 1 o'clock on Fridays and Saturdays. Now, we're not asking for special treatment, only equal treatment, and Rotherham District Council is very forthright in its commitment to fair and equal treatment to everyone. Oops, can you hear me? Okay, it's a bit odd, yeah, okay. Right, as you'll be aware, each application must be judged on its own facts and merits. The significant merits of this application of the premises is correctly conditioned with specific, appropriate and proportionate control measures, thus minimising any potential that any licensing objective would be undermined. Now, in this hearing, the burden is on the applicant, i.e. me and Anna, to show the proposed extension of licensable activities supported by the proposed operating schedule as amended by these two comprehensive policies, I should say, noise management and dispersal policies. It's unlikely, the test is whether it's unlikely to undermine them. Will it promote the licensing objectives? Is it unlikely to promote them? Any representatives opposing the application have the burden to show that these premises, trading under the pre-existing operating schedule and the enhanced noise management and dispersal policies before you, will undermine the licensing objectives and demonstrate that with evidence pertinent to the proposed operation. Now, in our submission, any subcommittee properly advised could only refuse the application if it's found on the evidence that the representatives to be no longer capable of promoting the licensing objectives. So you may ask yourself, why do representatives aka objectors need to produce evidence, and the answer is found in para 9.43 to section 182 guidance, which clearly states, and I quote, the authority's decision or your determination should be evidence-based, justified as being appropriate to the promotional licensing objectives and proportionate as to what is sought to be achieved. Significantly, there is absolutely no identified history of disorder involving these premises or the applicant before you. That is an undeniable and self-evident fact. So let me first walk you through who has, or rather in most part in this case, who has not made any representation or objection. Firstly, the police, being the lead responsible authority and source of expert evidence on all crime, disorder and ASB issues in Sussex, they've raised no objection to any of this. East Sussex Trading Standards and Children's Services, who are the lead agencies for the protection of children from harm. Public Health and the Planning and Highways departments have made no representation either. Now, if there were legitimate concerns, then they would be here in the room with evidence to argue vehemently against it, as is their statutory duty. We're left then with the objections from Environmental Health and 6 members of the public, with 4 further representatives providing support for this proposition. Now, Mr. Bontoft has been very fair and excellent. He's objected on the grounds of public nuisance. Now, he's described the noise abatement notice of December 2024 and has been scrupulously fair in stating that he's received the cooperation of Ms. Stewart in addressing those earlier concerns. Indeed, we've produced an acoustic report that he's referred to, commissioned to address those now historic issues. And we have strictly complied with that acoustic report ever since, hence no further complaints. You will see that, tellingly, no further complaints have been received since the 6th of January thereafter. Now, Mr. Bontoff continues to have some reservations about noise disturbances after 11 o'clock at night, where the promises to operate beyond that hour. To that end, we've served those new noise management dispersal policies, which he described to cover that eventuality, and he's generously described them as robust. He's mentioned some nervousness about whether those policies translate into action, and therefore we respectfully request that you incorporate these policies within the conditions of the current licence to make them legally enforceable. There's been a little bit of to and fro about the number of tables outside. Incidentally, just in the cross-examination beforehand, there will be 4 tables. Is that right? And how many seats? 4, was it?
2 to each table, so 8 people.
Okay, good. Thank you. Just to clear that up. Also, noise emanating from, there's been a suggestion that there should be a terminal hour, and the use of those tables outside should be dialed down from 2,300 hours to 2,200 hours. We have specifically addressed the management of that space outside in the noise management policy, which we invite you to encapsulate within the premises licence, so that the risk of that eventuality, the speculation that that eventuality may occur, is properly addressed within the hopefully varied premises licence. Okay, now we have 4 remaining representations from member of the public, and I'll take them together, and they cover, as they largely cover the same ground. I'll deal with the reported issues largely in the order that they appear in the bundle before you. They complain of public urination, defecation, used and discarding sanitary products in the car park, vomiting on doorsteps, taking drugs on the driveway. I don't think there is a driveway, do they? I mean around the side. On the car park at the rear, cigarette butts, people being loud and rude, intimidating males on the pavement, safety of women, girls and young families, the ever-present risk of aggressive violent behaviour and abusive language, a suitcase and an umbrella being left outside and run over, an error on the closing dates on the reps, obstruction of the pavement, noise after midnight, and noise after midnight from 2 other pubs and 2 other licensed bars, incidentally, not from this place, exposing minors to adult drinkers, thus encouraging learned behaviours regarding dysfunctional drinking and public health and related NHS costs. So that's sort of got all those reps down to some headings. So if we sort of allocate those headings, those concerns, to the 4 licensing objectives that lie before you, if you'll allow me. Right, drugs, ASB, violent crime, threat to women and children of all ages. The children of all ages, there's an element of protection of children from harm in there, clearly, but it probably fits best in this heading. Okay, I've served on the committee the crime and ASB data for this location for the past 6 months. That's that document there, sir. Okay. There is simply no history of any incidents being linked to these premises. In this part of the town, there were 14 incidents over that 6 months period, about 1 recorded every fortnight. There is 1 recorded ASB in the area, in the vicinity, not to do with a spa mind, but in that part of town, every 3 months. Similarly, there is 1 instance of damage recorded every 6 months, and 1 violent or sexual incident recorded every 60 days in that part of town. Lastly, there is only 1 drugs-related incident recorded every 6 months. Furthermore, crime and disorder in Rother. Can I have a little slip of your water? No, you're out as well. Okay, maybe later. Okay, is well below average amongst its comparator basic command units and the other divisions across Sussex Police. Now, para 2.1 of the Section 182 guidance tells us that the police are your main source of advice to the licensing authority on ASB and crime and disorder, and they have no objection whatsoever to this application. And so, with respect, it is not for others to stand in their shoes. Public safety. I have been unable to identify any issue pertaining to public safety because public safety licence and objective refers to people using the premises for licensable activities. At present, inside. You're very kind. Thank you, Mr. Randall. Thank you. Okay. That's where I'm up to on that. Now, the prevention of public nuisance, Mr. Bantos' area. This would be noise emanating from the building and the rubbish or human waste on the car park at the rear. We do not deny that there was an issue at the end of last year. Mr. Bontoff has addressed that in his representation, and there have been no further issues since the new year. Now, we've commissioned that noise report from a qualified acoustician and have implemented those recommendations. Now, you very astutely asked, did it extend to does this report apply to extended hours? Well, no, it doesn't. It extends to all noise leakage from these premises, no matter what time of the day or night. For your information, this report was conducted over data which extended for a 3-day time period. Okay, so no, it doesn't deal with noise specifically after 11 o'clock at night. It deals with all noise, okay, no matter what the time of day. Okay. Now, yes, we've discussed the noise management dispersal policies, and we've asked them to be legally enforceable, become legally enforceable. Lastly, were this variation granted, then it actually, again, you asked a really interesting question about people moving around the night time. Our position is it will reduce noise, as persons would not leave these premises and enter the street on their way to their next or final destination, would be much more likely to remain on site, i.e. the chapel bar. So, good point, well made. Hopefully I've addressed that for you. Now, the human waste and the case of the discarded suitcase and umbrella. Ms. Stewart is as disgusted and disappointed as the representative, who I believe is called Mr. Hurrell, with these occurrences. She maintains that she actually rents a large part of this car park, and therefore it is she who is the victim of this antisocial behaviour. She explains that there is more than adequate toilet and sanitary provision in her own premises, and that the perpetrators are therefore not her customers. And she asks, why would someone leave the chapel to attend to such matters in the car park when she provides comfortable and well-stocked facilities within? Now, as you're aware, rather because of the cuts and what have you, I don't want to get political here, but I appreciate all the pressure you're under, and thank you for all your efforts. You are running a scheme to do with toilets in Battle. Okay, it is my information, I stand to be corrected by those three gentlemen over there, but Ms. Stewart is the only bar that has signed up for that scheme. So any member of the public, customer or not, can come in and use this place. Okay, and also every other business which she owns in Battle, of which I think there are a further 3, are there?
3 altogether.
Yeah. Also have signed up to your scheme. So that's where we're up to with the toilet. Now, so the next thing is the suitcase and the umbrella, photograph of it jammed into the wheel arch. Okay? This is a property of a resident who moved out and left these items under the arch for collection by the binman. It certainly wasn't Anna's. It was nothing to do with her. Okay? It's just one of those things that happen. Somebody else put them out and somebody else's car went over them without her knowledge. Protection of children from harm. There is no history of children being exposed to harm at these premises. Trading Standards, who lead on this licensing objective, and Children's Services and the police, who are large stakeholders in all aspects of safeguarding, raise no issues whatsoever. There is an element of public health in this. Now, public health, as you're aware, is not a licensing objective in any event, as you already know. However, the Public Health Department themselves, a statutory consultee and responsible authority in their own right, take no issue with this application. There's another issue being raised, this lack of consultation. Now, we acknowledge that the blue notice displayed at the bar gave a final date for consultation 5 days after the council's published date on their website. This was actually an error we maintain on behalf of on the website, and we actually published the correct date. So in my opinion, it's a non-starter. Secondly, consultation in all these processes is very clearly laid down by statute 2003 Act and the accompanying 2005 regulations. Now, those provisions have been strictly adhered to the letter of the law, and clearly so. That clearly has that statutory consultation taken place and has been effective. Hence, we have this very public hearing. We have the mention of planning, that Mr. Godfrey has really dealt with it well, in as much that para 14.65 of the section 182 guidance says they're separate and distinct and therefore has no bearing on this. But just for your reassurance, planning, full planning application, just get it recorded. It's PP 13910215. It's the application number, was submitted within the time frame specified by your planning department. So if there are any issues with planning, those will be resolved by another committee under another regime and legal framework at another time and in due course. So look, committee, this hearing is for you to decide solely upon whether this variation, confined to the expansion of the modest extension of hours and the functionality to match those of their near competitors, will undermine or promote the licensing objectives. The representatives wish to use it, not Mr. Bantoft, sorry. The public representatives against this application seem to wish to use it as a review of the current licence for alleged breaches in the past. But starkly, this isn't a review, and therefore they cannot call for it to be reviewed. In my submission, were there to be empirical evidence of systemic problems emanating from this operation, then Parliament has already provided the correct mechanism to deal with all or any of them, that being a Section 51 review procedure under the 2003 Act. So, sir, even were you to grant this variation today and problems were to ensue, I don't suggest they won't, but I can look into the future as well as anybody else in the room, but were there to be problems going forward, then you still have all your powers under Section 51. Now, you will have read the 4 representations in favour of the application. I will let those speak for themselves on paper, but 2 of the representatives have been very kind and have turned up to lend their support. You may wish to hear from them. It's not for me to speak for them when they're in the room. Now, lastly, I just want to touch on some legal stuff for your legal advisor. Well, sorry, for you, but you may want to take some advice on this. Right. Let me talk to you briefly about fear and speculation. The representatives against speculate that were you to allow these additional hours and off sales, then they fear that further problems might ensue. There are 2 main reasons why fear and speculation are not admissible in these proceedings in my submission. Firstly, para 9.43, which I referred to earlier in the Section 182 guidance, clearly states that your decision here today, your determination, should be evidence-based. Fear and speculation about what might or might not happen at some undisclosed, or potentially happen, at some undisclosed point in the future, as a consequence of any decision you might make today, panel, is plainly not evidence. It is what it is. It is fear and speculation. Secondly, there was a ruling in the case of Daniel Thwaites and Wirral Magistrates back in 2008 before the Queen's Bench Division. It was their Honour Justice Black, and she indicated that your decision-making should be actuated by proper and real evidence. There is no recorded evidence in history or official reports or records of problems emanating from licensable activities at these premises, save the noise that has been, which has been addressed, and the lead responsible authorities who champion and lead on their own particular licensing objectives. They have raised no objection to it. And thirdly, and lastly, as an aside, I would respectfully point the panel's attention to another Queen's Bench Division decision, which is the case of Taylor and Manchester with TCG bars in 2012, which was a Queen's Bench Division hearing judgment handed down in Leeds, of all places, by Justice Hickenbottom, and my potted history of that in my submission. Any additional conditions that you might wish to hand down today should go no further, no wider than the subject matter of the variation before you, i.e. the additional hours and the off sales from the premises, and not beyond that. The whole of the rest of the licence is not up for grabs, if you know what I mean. That would be a review. Simply, you should address, in my submission, so I don't want to tell you what to do, that would be a big mistake. I invite you to address your minds and your decision-making to the matter that is before you. The extension of hours to match what's across the road and the off-sales. Okay, now, I've been a good 20 minutes. I apologise for that, but I've got a lot to tell you. I'll rest now and deal with any other issues, or during questioning, or actually in the summary. Thank you so much. Thank you.
Well, thank you. No, I mean, you haven't been lengthy at all, I think.
Oh, right.
I will certainly not hold that against you. Councillors, do we have questions? Well, would she like to speak separately from you, or?
If you've got particular questions, she's boots on the ground,
Yes.
and she can answer.
Well, I think perhaps we can question both of you together. Yes? Councillor Cooper.
Will there be a designated member of staff to help monitor outside? It says about control, reminding patrons to keep the noise down. Will it just be ad hoc, or will there be a designated member of staff to do that?
Every Friday and Saturday night, my husband are there, and we're on floor. We're not behind the bar. We're not doing anything else. So we are just there for watching what's going on, making sure there's nobody sneaking in that shouldn't be in there or misbehaving, and we're in and out the whole time. We have 23 indoor cameras and 3 outdoor cameras on the front, and they go to a screen behind the bar and go to 4 members of staff's phones as well. If ever I'm not present, which is hardly ever, recently I was pooling, and the whole time I'm watching telly, I've got my phone muted, and the outside camera's just on my phone, so I can ring through to the bar if they're missing something. We've been very, very strict. And what's called Elf Night, which is every last Friday, the town's mental. It's a really difficult night to police for all of us. And we stay after hours, usually for about an hour afterwards inside, just to police the street, because we want to make sure that our neighbours aren't saying, "Ooh, the chapel customers are like, we're closed, but we will help you." And my neighbours know that now, and they do ring me, and they're nice. You know, the same lady that's been dealing with you, she rang me just 2 weeks ago, I think it was 2 weeks ago, Elf Night, and she said, "He's still there?" And I said, "Yeah." I said, "Do us a favour." She had a load of louts in the side, and I was like, "I'll do it." And because they know us, and we're good with them, even though they weren't my customers, we've been shut for over an hour, they do as we say. We have a good rapport with them without it being, them getting aggressive, or we just say, "Come on, lads, you're upsetting, the neighbours. You're not allowed to do this."
Thank you.
Thank you. Councillor Stanger?
Just relating to the noise management, was it the noise noise assessment? Obviously, this was only assessed based on your current, I know you said it was an assessment of all the time, but obviously you have no activities after 11 o'clock, so it would be very difficult to assess noise after 11 o'clock based on that.
Yeah, oops, pressed the wrong one. I can take that. It's been going on for 3 days, okay? All noise, first of all, noise leakage, has been assessed. These are in the charts at the back. And what happens is you wind the noise up. And our acoustic expert went and spent time with a lady that's been liaising with Mr. Bontoft, and was present while that noise was turned up until such a level as it could be audible within her premises, her dwelling. And it's at that level, just below that. It's actually the vibration. It's not the noise, strangely enough. It's the rattling. Well below that, that is the level that the maximum of both live and recorded music is set. Is that fair to say?
It is, yeah.
But furthermore, sir, we've invited Mr. Bontoft. We've had a really, productive conversation. Profitable, I was going to say. Productive is the word. Conversation prior to this hearing. And he's due to, and very welcome, to come down to a site visit to check the operation of the amplifiers, the equalisers, and the noise limiter. And he can assist us to set a limit that he believes is acceptable. Would that be fair to say?
Yeah, no, what I was getting at is if you look at the external monitor and the internal monitor graphs, obviously they're only measuring to 11 o'clock because there's no activity after 11 o'clock, so it'd be hard to gauge what that, are they going to continue that red line, for instance, the top one, after 11 o'clock, or the external? So it's page 7 of the intro.
Sorry, I'll answer this one. It was recorded over 24 hours, and it can hear the noise from the bull across the road. And it stated that the noise that was outside of the premises did not go down when we closed at 11 o'clock. It was the same noise. We were not impacting the street. That was the main thing. It was to see if we had leakage into the street, which we didn't. And we also have a decibel reader in our foyer that's there 24/7 that we can see, all the staff can see, and all the customers can see as well.
Good answer.
Thank you. Yes, I've got a question. Really, it's a thought that's going through my mind, and I want to give you the chance to counter it. My thinking is about the area in front, extending the licensable area. I mean, I am familiar with Battle, and it's a very quite a narrow pavement, and not a very big area to be extended in the alcoves. At night, when many people are about, having tables or chairs there and encouraging people to come out with their drinks to drink there, there is a fear that would interfere with the passage of people on the footway and the busy main road that runs through Battle. Is that really going to be safe?
How are you going to police it? Tell them how you're going to police it, Anna.
The same way we police it now. So now we don't let anybody out there with their drinks, but people still go out there to smoke. And we make sure they're not, spilling out all into the street. And if they're just stood there chatting, sometimes a few of their friends will go in with them. I say, no, you're in or you're out. And our seating, we did have for quite a few months when we first opened, because we were under the impression we were allowed them, and we didn't have any issues, but we brought them in when our licensing police officer said to us, actually, you were allowed to have the tables, but you weren't allowed to have the drinks at the tables. He said, so if you remove the tables, it stops the encouragement of the drinks, which we did, until we've come for this variation.
Thank you. And there was another point there. One of the objectors said that regarding the courtyard, there had been no problem until you opened.
I was hemming and hawing, as they say in Cornwall, about raising this. The gentleman's not here, so he's not here to defend himself. But what I would say to you is that that gentleman made a statement to the licensing authority on the 7th of April saying, and you're absolutely right, prior to the chapel bar opening in 2024, there were no similar problems. And the problems he described, and I quote, is the yard is regularly used as a urinal and has even been a discarding tampon, as a smoking area and as a drug-taking area. Prior to the chapel bar opening, there was no nuisance in this area. Now that is an extract of his representation, timed at 12:29 on the 7th of April this year. However, sir, this isn't the first time I met you. I was here presenting on behalf of the application back in June of last year, and the very same gentleman's position on the 2nd of June was this, is in his representation of that date filed at 5:04 p.m. on the 2nd of June, where he clearly states, this area is frequently used by customers from the Bull for drinking and smoking during wet weather, and is also used as a toilet area. Okay, now, it is, I don't get too heavy about this, and it's a matter for Mr. Randolph, but clearly it's a criminal offence to knowingly or recklessly make a false statement in pursuit of a application, variation, or a review. But those two positions are absolutely irreconcilable, okay? And you may wish to, therefore, attach whatever weight you think is appropriate to the evidence of a man who says completely opposite between the 2nd of June 2024 and the 7th of April 2025. In our own defence, I wasn't going to mention it unless it was raised, but I have to deal with it now, so thank you.
Thank you. I think that's all the questions that I have. Councillor Stanger.
Yeah, regarding children, obviously, it's down to individual premises, but what's your current policy on children? Obviously, not unattended, you have an adult, but what is the policy, 9 o'clock, or is it just kind of, what is your general policy as a bar?
It depends on the day of the week. If it's a busy evening, we might even say 7 o'clock. We will make the decision on the evening.
Specifically on the 2 later nights you've asked for, so you wouldn't envisage children to be there till midnight?
No. The very latest we would ever allow would be 8 p.m. with parents. But if it was busy before 8 p.m, like if it was when the football was on, we didn't let anybody in after 5 o'clock because it's far too busy, I felt, to have children around with that many people drinking. But, for example, on a Wednesday, when we've got family bingo in, some people do ask, can I bring my 12-year-old with me? And there's only 20 people, and they're aged from 12 to their 80s playing bingo in families, then we allow it.
And the other part I was just going to ask, obviously your closing time is going to be the same time as your bar sales time, 12:30, which will be the same. How practical do you feel that is?
Do you know what? That's a brilliant question. I made a note to talk to you about that. Okay? Anna wants midnight. If you want half an hour's extra opening time, being open is not a licensable activity. So it is perfectly possible for you to vary this licence to have a closing time at 1 o'clock at night, but no drinks after the midnight watershed cut-off, which is when she wants. And then that drinking up time, that calming down time, is actually built in to the revisited licence today. Mr. Randolph, have you any objections to... He's the licensing authority expert.
It's not my place to object, but it's a sensible solution, and Mr. Semper's correct. Licensable activity hours aren't really carrying much weight unless you control them or review them at a review session. They're added in Annex 3. So that's something you can consider. I'm surprised that the application didn't allow for that in the first place. If they're trying to align with the ball, why wouldn't the opening hours extended nearer to the ball hours?
From a very practical basis, to get someone to drink up, have their last drink and be outside, and you'll be chucking everyone out at the same time potentially.
I didn't write that application, Anna did, and it's an oversight on her behalf, and you've nailed it, actually, yeah. Selling somebody a drink at 12:29, expecting to drink it and be out and sensible at 12:30 is just mad. So if you would extend the opening hours, please, to midnight, to 1 o'clock, being open is not a licensable activity. It's a clerical matter for the premises licence.
Yeah, just risk of disorder and taking someone's pint off them, they've just bought it, they could get upset.
Perfect.
Can I also add, we would decide when to shout last orders, depending how busy we are. So if we were very busy, we'd shout it much, much earlier than if there was 2 people in there, you've got some old boys, but we would have shut anyway. We would have gone, it's not worth to be open, but we do, it's not set in stone. Sometimes we will call it earlier if we think this is an evening when we're going to need that little bit more time.
Thank you. Anything else from councillors? No? Well, Mr. Randolph.
Yeah, just don't want to finish today without clarifying the numbers outside in the alcove. I mean, the applicants mentioned 4 tables, 2 people, so 8 people. But will there be also people standing? Because it's quite a small area, isn't it? So what I'm trying to get is that there is no spillover onto the pavement. Taking into account how small that area is, it'd be quite easy to work out what a reasonable number would be to be drinking in the area, either standing or seated.
I can't make them stand or sit, but I think that would be a reasonable number. And it's very...
What he's asking is, would you fix it at 8 people outside in your alcove area?
I could fix it at 8, but I might not even allow that many if I think they're loud or it's later. It depends on the clientele. But yeah, if we fixed it no more than 8, but sometimes I won't even tolerate that. And I don't, we're chasing people now. So I would just manage that. I think it's more about managing your clientele on the day.
I think I just have an observation there as to if there were to be a limit on numbers outside, I think that would be incredibly difficult to enforce, especially when it's busy. I think that would be very difficult to justify.
Yeah, I take your point because you were worried about spillage, weren't you? People obstructing the pavement, right? Rather than how many people are in the alcove area. It's a delicate balance, and the fact of the matter is, right? I assure you, knowing Anna as I do, if there are problems for the licensing authority or the police or the highways authority with people obstructing that pavement, she will deal with it because it's all indelibly recorded on CCTV, which these fine gentlemen have access to. They want to see it, and it will be addressed. Thank you.
Thank you. Now, I think Councillor Sanger has
Obviously,
another question.
mentioned in your licence, how often do you ever use SIA licensed people to manage events? The Door, for instance, because I know that's, and other venues when you've got a busy night, that's a way of managing how many's outside, inside, big events, and etc.
When we first opened, we did every Friday and Saturday night whilst we were seeing how things went and the lay of the land. And when we first opened, it was the Euros as well. So we had them for every Euro match and every Friday and Saturday night. And I found they caused more problems than they fixed. So, honestly, so we changed it to just as and when we needed, and it wasn't financially viable. We get some quiet Fridays and Saturday nights. So now if we know we're going to have a big evening, we have them, but I no longer have them on the door. I have them inside in plain clothes, and they just wear a lanyard. So they're there if I need them. So I do my own door.
And that's done on a risk assessment, case-by-case basis.
Yes, we write a risk
So how many
assessment.
private events do you have? Do you have a lot of private events in the evening, or is it mostly just for the patrons, live music type
Mostly
stuff?
for the patrons. We've had a few booked birthday parties, closed doors, and generally the booked birthday parties are never a problem. It's if it's a bigger evening, like New Year's Eve, bonfire night, things like that. And on bonfire night, it was my company that got all the bars on their SIA stuff because they'd never done it before. And I said I was doing it, and it was me that organised Bar Watch for Battle. Everybody's involved now. We all keep in contact with each other. We keep a shared bar list. So it's barred from one, it's barred from the all. And it was the chapel that organised everybody's SIA stuff for bonfire night. And it was just as well, because after we'd closed, it did kick off over the road. And my staff dealt with it.
They're not.
Do you have your own kind of personal policy for a last admissions type thing? So, for instance, if someone walks in at 12:15, if you got this condition, would you find that acceptable, or it just is it as
I'd
it
allow
comes?
them in, but I wouldn't serve them a drink.
Well, thank you. Thank you very much. Yes, we'll move on to the representatives. Yes, if they wish to speak, they may. Who would like to speak first?
I provided an email report on. Do you want me to read that out? Or?
I think we've read it. We've read the papers in front of us, okay. And your colleague there, Michelle
Eden, yeah.
Michelle Eden, do you wish to say anything?
I don't need to say anything. I just represent what I put in writing. I stand by my words. So if you've read those, then everything in there.
It's good. It's good of you to come. Councillors, do you have any questions of either? No. So yes, Mr. Semper, I think we get to the... And I was just going to say, I don't think we have Councillor Field here, do we? No, not here. Yes, I see that there are people in the public part. Is there anyone there who has made a representation and who would like to speak or to submit anything in writing even? No, no. Thank you. Right. So I think you, Mr. Semper, to sum up, I think. Am I right? Oh, sorry.
Apologies. The applicant should be have the last word. So if we
Sorry.
could go to the...
My eyes
Mr.
jumped a line on the list. Sorry. Yes, if you would sum up, please.
Sorry, I haven't prepared anything to start with on this. As it goes, I mean, I obviously still have my objection, still stands, but I think we have had some very positive discussions today. There's obviously some things for you to sort of take away and consider, and there might be sort of additional sort of conditions on numbers of people outside or hours of use outside to consider going forward. But otherwise, I don't think there's anything else from me.
Thank you very much indeed, and nothing else. No, thank you. So, Mr. Semper.
Can I just ask one question? Are we going to get a decision today, sir, or do we have to wait for 5 days?
Mr. Cowan will answer.
What we will do is we'll go into deliberations and we will get a consensus about how the councillors want to move forward with it, and we'll come back and confirm what's going to happen once they've had an opportunity to speak. Is that okay? Won't be long, just 5 minutes for them to confer and come back and confirm what's going to happen.
Perfect. A lot of places make you wait for 5 days, and I really don't know why. Okay, now look, it's been a great hearing because everybody's had their say, and we've had some real detail and got into the detail about virtually every aspect of this. My summary is just to very, very quickly remind you of what I told you, that the Section 182 guidance handed down by the Secretary of State is very clear, that your determination must be evidence-based, based on evidence, real and proper evidence even, justified as being appropriate to the promotional licensing objectives, and secondly, that any conditions imposed must be proportionate as to what is intended to be achieved. What does she intend to achieve? A comparatively modest extension of hours and facility of these premises to match what other premises already possess in the locality, if not directly opposite. Okay, that's it. The licensing authority, the advocates of the licensing objectives here represented by Mr. Randolph, excellently, expertly in Rother. The police are the guardians of all things that offend crime disorder. ASB in Sussex. The trading standards and children's services have a role to protect those children from harm that you rightly mentioned before. Planning department lead on planning. Now, all these expert responsible authorities champion their respective licensing objectives, and none of these professional bodies, you're right there,
Yeah.
raises any issue with the substance, content, or the additional safeguards. Environmental health, Mr. Bantoft, very helpful. He's reported issues, he explained that issues were reported last year. These have been addressed and remedied by the first week of this year. To avoid the chances of any repetition, we've added these policies. We invite you to incorporate them into the varied premises licence, and we look forward very much to Mr. Bonto's visit, whereby he can sign off on the precise levels on our limiter. Okay.
So sorry.
You not? You need another glass of water?
Yeah.
Do you want me to wait? Or-
Chair, if we could just wait a moment. I'm sure you're going to do that anyway.
Yes, we'll have to wait for Anna Stewart to come back. Of course, before COVID, we used to have water on the tables. It would be good if that came back. And Anna Stewart is back in the room, and we're resuming.
Okay. Right, there is no recorded history of crime, violence, ASB attributable to this applicant or her premises before you, or indelible evidence of any issues, or indeed any other cause for concern other than the noise. And that finished on 6th of January. That is an undeniable and self-evident fact. There is some vague inference that it might cause problems going forwards based on perceived problems in the past, and thus the representatives against have attempted to subvert this application for a modest variation of the licence into a review of the licence and the operation of the current premises licence. In my submission, they simply cannot do that, and there are insufficient grounds or reasons to refuse this application in my humble submission. Consequently, I respectfully request that you do indeed grant this variation. The premises licence is sought, supported by the 2 additional policies and the already comprehensive raft of effective conditions and any others that you may deem appropriate or proportionate or sensible, like the half-an-hour cooling down period suggested by Mr. Stanger, Councillor Stanger. Thank you very much indeed for your time. Thank you.
Well, thank you very much. I think that concludes the hearing, and we will retire to consider our decision, and we will let you know when we're ready to come back. Welcome back to this meeting of Rother's licensing panel, dealing with the Chapel Bar and Restaurant. We have listened carefully to all the submissions, and we are bound to be directed by the principal licensing objectives and material considerations of prevention of crime and disorder, public safety, prevention of public nuisance, and protection of children from harm. On balance, the panel accepts the evidence provided in support of the application to vary a premises licence, together with the letters of objection and support, and has decided to grant the variation application subject to the below modifications. And there is the list of proposed activities, days and times. Taking them in turn: retail sale of alcohol on sales, Monday to Thursday, 11 to 23 hours, Friday, 11 to midnight, Saturday, 9 a.m. till midnight, Sunday, 9 until 2300 hours, with a seasonal variation to midnight on New Year's Eve. That is all on sales. Coming to off sales, this is the retail sale of alcohol off sales, Monday to Thursday, 11 to 2300 hours, Friday, 11 till midnight, Saturday, 9 to midnight, and on Sunday, 9 until 2300 hours, with a seasonal variation to 1 a.m. New Year's Eve. Live music, Sunday to Wednesday, 1900 hours till 2300 hours, Thursday, 2000 hours to 2300 hours, Friday, and is that right? Friday and Saturday, 2000 hours till midnight. We note that no licence is required for the period 8 in the morning until 2300 hours. Coming now to the licensed activity, which is late night refreshment, and that will be from Friday and Saturday, 2300 until midnight. The hours the premises are to be open: the opening hours stated on the application form. Note that opening hours are not a licensable activity. Monday to Thursday, 1100 to 2300 hours. Friday, 1100 to midnight. Saturday, 0900 till midnight. Sunday, 0900 till 2300 hours, with a seasonal variation until 1 a.m. on New Year's Eve. Changes to the plan: the licensable area showed edged red on the plan at Appendix B be varied to the area shown edged green on the same plan. Existing conditions: the conditions imposed on the existing licence at Appendix H are retained unless they conflict with the variations contained here within. The conditions set out in the application operating Schedule D will be incorporated into the licence. I'm not going to read them out as they are part of the application. That takes me to... Yes. And the additional conditions: the following policies presented to the panel at the hearing are incorporated into the licence. That is the dispersal policy and the noise management policy. And we are conditioning that drinking outside will cease at 2200 hours. A copy of the panel's decision will be publicly available to all parties and published on the Council's website. And I have signed and dated this. I have to read out the right of appeal, Mr. Semper, though I think you know it. I'll just mutter it.
Chair, sorry. I would just say, please do read the right of appeal. It isn't just for the applicant. I would appreciate if you could read it. Thank you.
Under the provisions of Section 181 and Schedule 5 of the Licensing Act 2003, there is a right of appeal against the decision of the Licensing Committee if you are aggrieved at the outcome. This right of appeal extends to the applicant in the case of a refusal or restrictions on the licence or the imposition of conditions to the licence. The right of appeal also extends to persons who have made representations where the licence has been granted or that relevant conditions have not been imposed upon the licence. Full details of the rights of appeal can be found within Schedule 5 of the Act. Any appeal should be made to the Magistrates' Court, Edward Street, Brighton, within 21 days from the date of notification of the decision. You must contact the Magistrates' Court to establish the formal procedure for the appeal. And we shall give our formal reasons for our decision in writing within 5 working days of today. And unless there are any submissions or comments, that concludes today's hearing.